All right, another great lackluster video right here that you're going to see. And this is a great example of somebody who knows their rights, knows the script or the philosophy of the script, and knows laws better than the cop that is looking to arrest. So here, check this out. And this is just a sad state of affairs when you have supervisors, cops in charge who don't know the fucking laws that they're sworn to uphold. This is happening all over the country. It's fucked. Check this out. Thanks, lackluster.
Am
I being detained? Suspicion of what? What crime?
I didn't say there was suspicion of a crime. I am lawfully here, and I am lawfully asking for your identification because I had a call. If you don't want to give me your identification, then you can come with me, and I can hold you until you identify yourself.
Welcome back to the Lackluster channel. Today's video was submitted by a viewer named William, who was walking home on October 6th of 2021 at around 7:30 in the evening. After walking past the Middleport Police Department in Ohio, an officer with badge number 13 pulled up next to him and alleged that he got a call that William was in and around the vehicles in a parking lot. William denies the allegation. The officer asked what he was doing, and William told him that he was walking home. At this point, he asks for the officer's badge number, and the officer pulls into a nearby lot. That is when William starts recording.
Okay, go ahead and show me some ID.
Am I being detained?
I'm going to identify you.
For what crime?
Because I had a complaint.
Suspicion of what? What crime?
I didn't say there was suspicion of a crime.
Well, I don't have to ID unless you suspect me of a crime.
You need to identify yourself to me.
Well, the law is if you suspect me of a crime.
I am lawfully here, and I am lawfully asking for your identification because I had a call that you were in and around a bunch of cars over here. So I need to know who you are and what you were doing.
I wasn't doing anything. I don't know who called.
It doesn't matter who called. I have a complaint, and I'm following up on my complaint.
In the 2000 case of Florida v. JL, the United States Supreme Court examined the use of anonymous tips by police officers. In the case, an anonymous call reported that a black male wearing a plaid shirt and standing at a bus stop had a weapon in his pocket. Officers responded without any further corroboration and reached into JL's pocket and seized the gun. At trial, he moved to suppress the gun as evidence, arguing that the frisk performed by the officers was illegal under the Fourth Amendment, and the court held that an anonymous tip of this nature that merely describes a subject at a particular location does not satisfy the requirements of reasonable suspicion necessary to justify a frisk. A mere anonymous tip, standing alone, does not constitute reasonable suspicion or probable cause. An anonymous telephone call may justify the initiation of an investigation, but the court has held that alone, it will rarely establish the level of suspicion to justify the detention or require one to identify themselves.
It doesn't matter who called. I have a complaint, and I'm following up on my complaint. Now, I'm asking you nicely for your identification. If you don't want to give me your identification, then you can come with me, and I can hold you until you identify yourself.
Well, every minute that you hold me, you're going to be held accountable, and you'll violate my civil rights. Am I being detained?
At this time, you are, if you're failing to identify yourself.
Okay, well, at this time, I'm going to invoke my Fifth Amendment right to remain silent.
Alrighty. Turn around and place your hands behind your back.
Yes, sir. I do have a knife on my side here.
Okay.
It's just like a little pocket knife.
That's cool. All you have to do is tell me who you were.
Well, I don't have to. I don't have to under the law. I don't have to unless I've been lawfully arrested.
Okay. What do you call that?
An unlawful arrest, and we'll see you in court. And you'll lose your qualified immunity.
Lean up against the car.
I don't consent to any searches or seizures.
Okay, that's fine. I don't need you to at this time. You're failing to identify yourself.
Failure to ID is a secondary charge. I have to be.
Okay, where'd you get your law degree?
I have to be lawfully arrested before I can fail to ID.
I'm detaining you until I can identify you.
Under suspicion of what crime?
I'm detaining you until I can identify who you are.
I'm requesting.
I'm not talking to you no more.
Okay.
It's already done.
I'm requesting your sergeant out here. Your supervisor, please.
I am the supervisor on duty at this time.
Can you get Monty Wood out here?
No, I cannot.
Again, I don't consent to any searches or seizures.
Okay, that's fine.
Section 2921.29 of the Ohio Revised Code covers the failure to disclose personal information. It states that no person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by law enforcement officers who reasonably suspect either of the following. Number 1, the person is committing, has committed, or is about to commit a criminal offense, or if they were witness to a felony. William was neither, and the officer recognized that fact early into the encounter.
I didn't say there was suspicion of a crime.
But this is a prime example of the sad state of policing in America today. The officer claims to be a supervisor, but doesn't know the very basics of the laws he is to enforce. It's rather embarrassing to see officers in leadership positions who disregard the Fourth Amendment to such a degree that they believe that they have the authority to detain and identify someone based on frivolous information and with complete absence of reliable evidence. William was arrested and charged with failure to comply by refusal to identify. Unfortunately, the department lacks transparency and has no body cams or dash cams. William's attorney filed a motion for discovery and received nothing. Instead, the prosecutor offered to dismiss, but only if William paid the current court costs. William refused the insulting offer, and instead, at his pretrial appearance on January 4, 2022, the case was dismissed. A public records request for the original police report and parking lot video is being filed as they still never received discovery. A civil suit for his unlawful detention, subsequent arrest, and various Fourth Amendment violations is being prepared. Hopefully, the judgment or settlement requires some sort of constitutional training for the department's officers.
And have a seat in the back of the car.
You can grab a water bottle for me. Thank you.
Good?
Yeah.
Your water bottle?
Tight fit. Thank you.
There's your hazmat.
Thank you.
Central to 23. I'm gonna hold on to the knife.
Sure. So guys, this is Middleport Police Department. Today is October 6th, 2021. Can I ask one more time?
I'm done talking to you unless you want to identify yourself.
Okay.
Then you can get back out of the car.
Okay. Badge number 13.
Thanks for watching. If you have a video you'd like me to review, email it or send it in via Facebook Messenger. You can also view this and other content on my website. If you're new here, subscribe for future content. If you've been around for a while, remember to like, share, and comment down below of what you think of this interaction. Shirts and other goodies are available at the Teespring store linked below. Channel memberships start at just $1 if you'd like to further support the channel and get a slick lack logo next to your name. I'll see you in the next video. All links are down below.